I'm Mark Golub, and in the news, all over the news, especially on American television, is the issue having to do with the Boston Marathon, the very troubling events that occurred on Patriots' Day when the annual marathon was turned into a moment of extraordinary tragedy, as obviously people lost their lives, as people lost their limbs, as families now live in the aftermath of tragedy. And it was not only a tragedy for the city of Boston, but in many ways it was a tragedy for the entire nation. And there are issues which simply remain unresolved and part of the national debate today. Who is behind the bombing? Is it an act of terrorism or simply the sick act of warped kids? Is the fact of it somehow a symptom of a breakdown in homeland security? And what should be done now is Dzhokhar Tsarnaev, who was captured by authorities in Watertown, Massachusetts, and who will now stand trial either as an American citizen or as an enemy combatant. And the talk shows are just full of speculation, accusation, rumor. And so while this is not a specifically Jewish issue, it is an issue of American Jewish concern. And to explore some of the issues with us, I am most pleased to have on our phones right now, from his office in Dallas, Texas, the former Deputy Director of the FBI, the Federal Bureau of Investigation, and a gentleman you've met before here on Shalom TV, Buck Revell. And Buck, thank you so much for joining us.
I'm glad to do it.
Buck, I don't know whether you've had the opportunity to have any information given to you that is not out there in the general public, and I'm sure you've seen how, again, on television, everybody is speculating. But in terms of your own best guess, is it your sense that these two individuals, the Tsarnaev brothers, did they act alone, or are they part of a larger plot, some kind of terrorist cell?
Mark, I think it's really too early to tell. We don't know what happened when the older brother went back to the Caucasus and apparently to Chechnya as well. And until we really find out what went on there, I think it's too soon to say that this is a self-induced act. In other words, the self-radicalization that is referred to so often. We've had those cases in the U.S., and certainly people can do harm on their own. But the big concern is this part of a larger network, and should we be on guard for potential further acts of violence by people connected to this network? Of course, there have been 3 individuals now arrested that are essentially charged with being associated with after-the-fact actions that aided and abetted, but they have not been charged with anything about co-conspiring to commit the bombings at the Boston Marathon.
Yes. Buck, I want you to address the question that somehow has taken over the news channels and the talk shows, and it has to do with the way in which there seems to have been a conflict between the FBI and the Justice Department over what could or could not be done in questioning the suspect when he was in the hospital. And this is what we're told, and I want you to help clarify it for both me and for the viewers of Shalom TV. Did the Justice Department, in your view, Buck, and again, you served as Deputy Director of the FBI for a major part of your professional career, did the Justice do anything wrong or inappropriate by in some way interrupting an FBI interrogation of the boy in the hospital and insisting on reading him his Miranda rights, after which he stopped speaking? There are those who are accusing the Justice Department of doing something inappropriate, and at the same time there are other talk shows which argue American citizens have Miranda rights and that the Justice Department did nothing inappropriate by effectively instituting those in the middle of an FBI investigation. What is your sense of what happened there? And can you please clarify what was appropriate and if anything was inappropriate?
Mark, it's inappropriate for a magistrate to initiate any legal proceedings. The FBI needs to present the case to the department. They need to determine what charges are to be filed. Then you go before the magistrate. Until that point, the magistrate had absolutely no jurisdiction. If I had been in charge in Boston, that magistrate would not have entered that room. There was ample reason to continue the interrogation. It was totally voluntary. He was not being coerced. He was being cooperative. Now, what you give up when you do that is the ability to use anything he might say for purposes of prosecution. But at this point, you're much more concerned with the intelligence about, are there other members of this particular plot? Is this plot part of a larger scheme? And what is the ongoing danger to the American, to society? That magistrate would not have entered the room unless he, or in this case she, had a direct authorization and order from the Attorney General. And I don't think that was given. And I think it was an initiative that she took, and she had the U.S. Attorney with her and the public defender. And frankly, if I was Bob Mueller, I would have, at this point, said, this is not the way that it's supposed to work, and cease and desist, and we'll tell you when we're ready to bring him before the magistrate after charges are filed.
So, Buck, what you're really saying is that you feel there were really two failures from your perspective. On the one hand, the magistrate had no business entering that room, but you're a little bit upset that the FBI did not have someone there like you who would have said, you don't belong here and we're not handing this room over to you until we're done with our investigation or our interrogation. Do I have it correct?
Yes, if I was the agent in charge, if he was given notice, I'm not sure they didn't disbarge in, but they should have had instructions that no one enters the room without his specific approval, and then the agent in charge should have contacted the Director Mueller, and then he should have determined that the Attorney General had approved this or not approved it, and he should have, if it hadn't been brought to the Attorney General, he should have opposed allowing access. So this should have been escalated to the Director and to the Attorney General, where a rational decision could have been made. And in this case, a rational decision is, do not worry about evidence for trial, worry about protecting the public and preempting any further attacks or actions. There is ample evidence without any statements by Zohar to use in the trial. So your first duty is to public security. That's the reason there is, in fact, a public safety exception to the Miranda warning.
Yes. And I want to make sure our audience understands the subtlety of what you've said, because I believe it's very important, and I have heard other individuals try to explain this. The Mirandizing of a suspect means that he is given the right not to speak without counsel, and that anything he says after that can be used, may be used in trial against him. And your point is that if someone is not Mirandized, anything he says may not be used, or really should not be used in trial against him, and that the Mirandizing of a suspect not only protects the suspect's rights, but it also means that something he does say can be used against him in trial. And therefore, what the Justice Department gives up, or what a magistrate, a local authority gives up by not Mirandizing him, is that anything he says at that point is excluded in any subsequent trial. But that if a magistrate or a local authority is willing to sacrifice the use of information derived during an interrogation prior to Miranda, the only thing that is being sacrificed is the use of that in trial. And your point is that there was other evidence against him, that we didn't need what he said in the hospital room, but that even if it meant giving up evidence that could be used against him, there was a much more overriding goal and purpose to this, gaining information that might help the FBI and the United States government both prevent another event, whether it would be in Manhattan or elsewhere, and find out information about whom this boy was working with. Have I basically summarized it correctly?
Well, with one exception, magistrates in the United States, these are federal magistrates, have no investigative authority, none. They're not a grand jury. They have no authority to conduct independent inquiry unless they're appointed by a judge to do that after a matter is brought before the court. But this case had not even been brought before the court. So this magistrate, unless she was authorized by Main Justice to do this, was acting totally out of the scope of her authority and responsibility. And it should have been, in my view, a situation that was decided by the director and the attorney general, not by the local magistrate and perhaps the U.S. attorney.
Buck, giving her every benefit of the doubt, what was the best reason you think she had for walking in and stopping that interrogation?
Well, there was a lot of speculation in the media as to when it would be appropriate to use Miranda, how long the public safety exemption would apply, and whether the individual rights might be violated if they didn't Mirandize them at this point. And again, it's up to the government to decide whether they even want to use any statements the individual makes, not the magistrate. So in this case, I think that it was totally uncalled for, and if Attorney General Eric Holder made this decision, then it's one that he should regret, and hopefully would not be repeated in the future, because certainly we're going to be dealing with issues like this again.
You don't know, however, for a fact whether Attorney General Holder was involved or not.
I don't know if Holder was involved. I don't know if Mueller was involved. I do know that the magistrate went in. It's been said that she did it on her own, but the U.S. attorney and the federal public defender were with her, so obviously there had been some coordination between those elements. The magistrate is an officer of the court, which is a separate branch of government. It is not part of the executive branch. It's certainly not part of the legislative branch. So by the magistrate interjecting herself into this case, she overstepped the bounds of the judicial branch of our government. Mm-hmm. And without the authority of the Attorney General, there should be sanctions against her for doing that.
By the way, and I want to ask this question in a respectful way so that you can answer it in as respectful a way as you can. And by the way, I just want our audience to know, I've had many conversations with Buck Revell, and one of the things he is always respectful of those who now have positions of authority and positions of responsibility. And so I'm trying to tread a line here where I do not ask him on American television to, in some way, publicly criticize an individual. But I am going to ask you, Buck, in some way, this sounds like, excuse my language, an enormous screw-up. And if it is, this is not the first time you have seen the government make this kind of mistake. But I'm going to ask you one more time, do you have any sense as to what drove the decision here that really prevented the FBI from doing what had to be a very important, necessary, complete interrogation? Why the screw-up, Buck?
Well, I think, again, it was all of the ongoing debate in public. And you have to remember where this was. This was in Boston, Massachusetts, the home of Harvard, and the sort of the hotbed of a liberal approach to the constitutional issues. Not saying that that's wrong, but if this had been in Dallas or in Oklahoma City, we wouldn't have this issue. But the fact of it is that whoever made the decision, and if it wasn't done with the approval of the Attorney General, it was inappropriate.
Okay. I want to pick up on what you've said because it's interesting. Here you are speaking on Shalom TV, and in the Jewish community, there is the entire spectrum of opinion although overwhelmingly the Jewish tradition and the Jewish people have leaned liberal. And one of the things that was said by Jon Stewart on The Daily Show was, well, don't Americans have the right to be Mirandized? And if, in fact, it is simply a liberal or conservative perspective, then obviously those who have a liberal perspective are going to be glad that the magistrate on her own went out of her way to protect a kid who was being investigated or interrogated by the FBI. And I want to understand from you, because I know the perspective you bring, which is neither left nor right. You are basically trying to enforce what you believe is the law, and there have been times when you have taken very courageous stands on what would normally be called the liberal side of the argument. But I'm now asking you, if in fact in Houston or Dallas or Oklahoma City, this might not have played out the same way it did, and at the same time you say it's not that you're against a liberal understanding of the Constitution. If one has a liberal perspective, Buck, is there anything inappropriate? How would one justify not bringing the magistrate in and not Mirandizing this boy?
Very simple. Miranda only protects a person against self-incrimination. And if you have made a decision not to use anything that the person says in order to prosecute him, then you don't have an obligation to invoke Miranda. So that is the whole essence. He was not losing any rights if the government had chosen not to use whatever he said against him. And so, that's not liberal or conservative. That is, in fact, what it means. Mm-hmm. Miranda does not say that you can't prosecute someone if they're not given a Miranda right. It simply means you can't use anything they've said or the fruits of that information in the prosecution against them. And the government has a right and really the responsibility to exercise that determination if other lives are at stake. And in this situation, that was still the case.
Yes.
So no one is arguing that if you were going to prosecute him, anything that he said could, without Miranda, could be used. That simply was already a given. But the information could certainly be used if he gave information to attempt to preempt any further terrorist activities by a group or organization, or even if they had additional explosive devices that they had planted in different areas around the city. Those are overwhelmingly public interest issues. Whatever he might say to be used in prosecution is a much lesser concern, and he does not lose any rights. It simply can't be used.
Okay, then I want to say to you, I want this to be the attitude of the United States of America, whether it's in Boston or Oklahoma City or Dallas or Stamford, Connecticut. I want the perspective you just brought to be a non-liberal, non-conservative issue. I believe it is the way in which the government should handle situations that are tragic like this. And, I don't know if you want to comment on that, but I'm expressing my own sense that the way you describe it has nothing to do with one's political leanings left or right. It has to do with what happens when at least two individuals plant bombs in the middle of a Boston Marathon, and we are concerned about whether there are other bombs planted somewhere else, and we really need to know whether these kids, whether it's something they did on their own, whether this kid learned whatever he learned on a trip to Russia or Chechnya or wherever. Was it from an Al-Qaeda magazine, which doesn't sound likely to me, but it also doesn't sound likely to me that two kids are able to build a bomb with the kind of trigger they had using toy devices of some way, somehow. And I would want this to be the perspective of America, Buck, whether it's Boston, Massachusetts, Manhattan, New York City, or Oklahoma City. And what would your comment be?
Well, you would hope that would be the case, but there are over 90 different federal districts in the United States, and the opinions and the circuit courts of appeal all the way up to the Supreme Court, you'll have different circuits ruling different ways on similar circumstances. But in this case, I think it is extremely clear, and it has been ruled on by the Supreme Court, that it's up to the government, meaning the executive branch, to make a decision as to when a person is brought before the court. And that means charges are filed, and then, of course, if they haven't been Mirandized, the magistrate or the court would do so that anything they said subsequently would be subject to the restrictions of the Miranda requirement.
I understand.
Up to that point, if the government chooses to try and elicit information and is willing to waive the right to use that information for prosecutive purposes, that individual's rights are not being violated.
I understand.
What you're doing is you're protecting the right of the public to be protected from terrorist or criminal activity. And so I don't look at it as a liberal or conservative, or I look at it as being a practical and constitutional implementation of the rules and the duties and responsibilities of our federal government, which are divided specifically into three separate branches.
Okay. Let me ask you one more question on just conceptual issues that have been raised by this case. Explain to us the difference between trying an American as an American citizen who has in some way done a criminal act, as opposed to somebody who is classified as an enemy combatant, even if he is a naturalized or a Native American citizen.
Well, in my view, the only way to try an American as an enemy combatant is if they are overseas and are part of an ongoing insurgency or combat activity. If they're arrested for acts committed in the United States, I believe the only legal and proper way is to take them into federal court under the federal statutes. So I don't think the whole enemy combatant dialogue really has any specific meaning.
Very interesting.
For Americans arrested in the United States. I think that's a very clear and precise meaning that they must be tried in federal court. And we've had several hundred cases in federal court where that has been upheld all the way to the Supreme Court.
I want to understand this one more moment. We had the Oklahoma bomber who blew up a building and was then tried as an American citizen. There is a suggestion, again, I'm talking about what you hear on the talk shows now all the time, Buck, that somehow the Tsarnaev boy should be treated differently because he may be, or his brother may have been, involved in a terrorist group, a terrorist cell, Al-Qaeda, Islamic group of some kind, in jihad against America. What I hear you're saying is that basically if these young men, as warped as they may be, are American citizens, whether they are somehow influenced by part of a terrorist or Islamic cell or not, it would not change the way you believe American law should be applied to them.
That's correct, and the American law has been applied very successfully. You go back and look at the first World Trade Center bombing in 1993. We convicted all of the perpetrators of that, and one of them actually drove up and drove the truck into the basement from Dallas. We captured another one, the ringleader, was captured in Pakistan and brought back to the United States by rendition. And they were all convicted. The shooter at the CIA was in the United States, a permanent resident alien, fled to Pakistan. He was arrested with the support of the Pakistani authorities, brought back to the United States, tried in federal court, convicted and actually tried in state court, convicted and executed in Virginia. So we have had an outstanding record of being able to deal judicially within the civil system with acts of terrorism. Now, where you get into problems is if they're captured on a battlefield, if they're captured in Iraq or Afghanistan. You don't have the same means to collect evidence. You don't have the ability to conduct a forensic investigation, identify witnesses, and so forth. That's when you get into the appropriate use of the category of enemy combatant. Mm-hmm. And that's where essentially you're dealing with law of war rather than with the the constitutional requirements in the federal code within the United States.
Okay, so some of the discussion we're hearing right now, again on American television and American talk shows, how should this boy be tried? Should he be tried in military court? Should he be tried in American civil court? For you, that really is a red herring, and it is more, again, a symptom of ideology, not a product of American law.
Well, even those that are saying he should be treated as an enemy combatant have acknowledged that he'll have to be tried in a federal court, not in a military court. Since, of course, the act was committed here in the United States. Their premise is, well, if he's declared an enemy combatant, he can be held for questioning until it's no longer viable and then turned over to the federal government, to the Justice Department for trial in federal court.
Okay.
I think that is a very there's difficulties with that, and there are, if they're properly utilized, sufficient latitude within the federal rules of criminal procedure and the U.S. Code to try these cases, and they've been tried very well within the federal court system.
Buck,
So,
forgive me for,
again, I think that,
Buck, forgive me for interrupting you. I only have 1 minute left, and I want you to address one more question in 60 seconds. The other charge has been leveled against the FBI, the CIA, Homeland Security, that somehow this event was a failure in the organizational ability to protect American citizens. To what extent is there any validity to that accusation from your perspective?
well, I know that the FBI took a very good look at him when the first information came from Russia, which was essentially that they had information that he was tending toward radicalization. They checked all the databases. They did interviews of he and his wife, and they found nothing there to support that. And at that point, they closed the case. Now, they did not get information that he had gone to Russia. They did not get information that he had come back. So that probably would have triggered and should have triggered a reopening, particularly since he had gone to the Caucasus and to Chechnya, of the case. Now, the failure to notice that he had left and come back, I think that is a mechanism that needs to be examined to determine why, and the CIA got a separate warning, why these bits of information were not all brought together. But as far as the FBI closing its case initially, that is what is required by law. If you find no basis to keep a case open and you report back to the Russians that there's no indication of radicalization at that point, and that was in 2011, then I don't think the American public would stand for keeping cases open indefinitely based upon ambiguous and unsubstantiated information.
I understand. Buck, it is always extraordinarily kind of you to give us this kind of time and to share the expertise you have. You can imagine how it is just delicious to be able to talk to you and to bring your perspective. And as always, I thank you, my friend, for being with me, and we'll talk often and we'll talk soon.
Okay, very good.
Thank you,
Appreciate it. Take care. Bye.
The thoughts of Buck Revell, former deputy FBI director, and many of the things he said puts into much better perspective the kind of discussion we're hearing all over American television and on the American scene today. I hope it's helped you. My thanks tonight to Naomi Vilko for helping me with this edition of In the News, to Sloan Copeland, Dora Golub, as always. It's wonderful to be with you, and we'll see you again next time. Until the next time, I'm Mark Golub. Be well, my friends.